Okay, class, this is going to be your test 140 number 1, lit. Let me give you some proper names. Just a minute. Names. You have Officer Sam Hawley, New York Police Department, Logan Street, 4th Avenue, New York City, Buick, Judy Gordon, Spring Avenue, Pearl, Central Avenue. Okay. And this is going to be 140 lit for 5 minutes. And it's your number 1 lit. The defendant was found guilty by a county jury of murder in the first degree with a sentence of life imprisonment. On the evening of July 25, 1983, at approximately 9 p.m., Officer Sam Hawley, then a member of the New York Police Department, was shot to death with his own gun. The shooting occurred in the area of Logan Street and 4th Avenue in New York City. Although there were some conflicts in the testimony, there was sufficient evidence from which the jury could fairly find not only that the defendant killed Sam Hawley, but also that the killing was deliberate. On July 25th, the defendant was driving a 1978 Buick sedan, which had been stolen several days earlier. He visited with his mother, had some beer and other alcoholic beverages, and spent a good part of the day and the entire evening in the company of his girlfriend, Judy Gordon. She was married at the time, but was living separate and apart from her husband. She had one child, a little boy. After having dinner with Judy at her apartment outside the city, they drove into the city, first having left the child with a friend of Judy. In New York City, they stopped at 2 bars where the defendant had some drinks of whiskey. They returned to the Buick, which they had left in a parking lot. The defendant backed out of the lot, drove up Spring Avenue to Pearl, then on the highway and along Central Avenue. They finally cut across to Logan Street. At Logan and 4th Avenue, the defendant sideswiped a car that was parked, and at the next corner, he struck 2 cars which had stopped for a red light. He got out of the car and began walking up Logan towards 4th Avenue. There was conflicting evidence as to the manner of his walk. The state supported his assertion that his appearance and walk were normal. At one point, Judy testified that when the defendant got out of the car, he was white and acted like nothing had ever happened. He told her to get out of the car and go with him. At another point, she testified that although the defendant did not fall against anything, he did appear unsteady. At the time the defendant ran into the cars at Logan and 4th Avenue, Officer Hawley was in a nearby tavern owned by his brother-in-law. He had been working there and had not been drinking. He was about to go on duty in an hour and was wearing his police shirt and pants and a brown-colored jacket, which was open. His gun was in his holster. He began following the defendant up Logan towards 4th Avenue, and as the defendant turned into 4th Avenue, the officer called to him. On direct examination, Judy testified that she heard the officer say stop, but did not recall the rest. The officer reached the defendant and a struggle took place. There were several eyewitnesses who did testify, and although there were differences in the testimony, their basic observations were much the same. The defendant had managed to knock the officer down, and while the defendant was on top, a shot was fired, striking the officer. At this point, several witnesses observed the defendant standing or slightly bent with the gun in his hand, while the officer was grabbing hold in an effort either to pull himself up or to pull the defendant down. Then they saw the defendant fire 2 shots into the officer at very close range. Medical testimony confirmed that these shots were fired from the gun while it was almost in contact with the officer, and that the bullets entered the officer's body at a down angle. An additional shot fired by the defendant from a slightly greater distance also struck the officer. 2 further shots were not aimed at the officer. One was fired at a witness who was running up to see what was happening, and the other was fired at the driver of a bus which had stopped at the corner of Logan and 4th. The last shot struck and slightly and so we have on your 140 lit number 2, Detective O'Brien, T-shirt, Detective Wolf, John Claudio, Women in Blue, David Perez. This is going to be 140 lit number 2 for 5 minutes, you all. Detective O'Brien sees the defendant come out with his T-shirt in his hand, and he sees the defendant go straight to the vehicle, open the door, and get inside. The videotape captures what happens inside the vehicle, his driving the vehicle. The videotape also captures how he uses the T-shirt while he's inside on the steering wheel, on the shifter, how he's looking around. The video also captures that heavy breathing, that heavy, excited breathing, and of course, the statements that he makes that, "I'm stealing this car," and that he's going to take the radio. Now, Detective Wolf also testified that while he was at that location, or when he came upon the location after he lost sight of the vehicle, that he saw the defendant with a T-shirt in his hand and the keys. And you can see in the videotape that the defendant struggles for a while there, but he actually pulls out the keys out of the ignition. So Detective Wolf sees him with the keys to the car in his hand and the same T-shirt that's in the video, and that he sees him get into the car with. He also testified that there was only one other person there, a person they identified as John Claudio that was released. Detective Wolf also testified that the team was in charge of that vehicle and that the defendant was not a part of the team and that nobody other than the task force had permission to use that vehicle. Detective Wolf also testified regarding his opinion regarding the movement of the vehicle. Okay, as you recall, he testified about his training and experience and how he's been working this task force for over a year and a half now. He has lots of training and experience on patrol with audio or auto theft, and it was his opinion that the defendant moved this vehicle only a short way from a public open out in the alley into the secluded, very difficult place to see parking spot indicated on this photograph and also in the videotape that's marked Women in Blue. He testified to his opinion as to why something that would happen, why someone wouldn't take off down the alley. And his opinion was that it was moved a short distance to possibly strip the vehicle or to allow for a juvenile. And he testified typically it's in gang situations, a juvenile to come and do the dirty work. Just plant that in the back of your mind for a second. Before I move on from the unlawful taking of the vehicle, I want to point out one other thing. Defense called a witness, David Perez, and he corroborates exactly what's on the video in terms of the defendant getting into the car. Didn't have permission, and it was a stranger's car, and that he moved the car. Whether there's an excuse or not is not a legal defense. There is no defense. I didn't know or I thought I had permission. There's just no defense to that. So the defendant's own witness gets up and testifies, yes, the defendant got into a car that didn't belong to him, and he moved it without their consent. Okay? And he also confirmed that he knew about stolen cars. He knew about stripping them. He knew about joyriding, and he knew about a fence. Looking at the totality of the circumstances regarding the evidence presented regarding whether or not the defendant unlawfully took a vehicle that did not belong to him with the specific intent to permanently or temporarily deprive that owner of the car, I will submit that the totality of the evidence shows that the defendant will be guilty beyond a reasonable doubt. Again, just one more time, not to belabor it, but there is the evidence on the videotape and the defendant saying that he's going to steal the car in terms of his intent, but also the fact that he moves it from an open area into a secluded parking lot where nobody can see it. As the officer will testify, he drove right by and didn't realize it was parked. And we'll get ready for your 120s. 120 number 1, you have Officer Levson, Whittier Barrio Loco, Little Man, WVL, Whittier, Sur, Sureño, Southern California, Northern California, Detective O'Brien, Bugsy, Efren Barajas. And this is going to be 120 number 1, and it's from your speed building, okay? From your speed building for 5 minutes. Committing the crime for the benefit of the gang. Again, specific intent crime, and let me go through the elements with you. I know the judge read them to you, but just briefly. To find this element true, you need to find that the defendant committed a crime. Committed a felony, unlawful taking of a vehicle, which has been established by the evidence presented that the felony was committed for the benefit at the direction of or in association with a criminal street gang. Now, you heard the testimony of Officer Levson. He's an expert regarding criminal street gangs, and specifically he qualified as an expert regarding Whittier Barrio Loco. He testified that based on his training and experience, he's familiar with that gang, that it's a gang that's constituted of over 20 active individuals, that it is a gang that commits crimes such as murder, robbery, assault, attempted murder, witness intimidation, theft, auto theft. He testified to a whole string of things that he's familiar with that gang participates in. So he testified that the gang Whittier Barrio Loco fits in the definition of criminal street gang. He also testified regarding personal knowledge that he has of the defendant in this matter. He testified that he knows the defendant to be Little Man from Whittier Barrio Loco. He testified that he knows that not only has the defendant admitted to being a gang member in Whittier Barrio Loco, but that he continues to be active and that he has tattoos. He has WVL, I believe, on his arm. Get the photographs here. WVL on his arm, on the inside of one of his arms, and that he has Whittier tattooed on his back and on his hand. And on this Whittier, it also says 13. His hand has sued on it. meaning sureño, meaning a Southern California gang versus a Northern California gang. So he testified based on all of these things that the defendant is an active member of Whittier Barrio Loco. He also testified, and this becomes key when you look at the totality of the circumstances and the enhanced cassette tape. Prior to getting into the vehicle during that 4-minute span from the time that Detective O'Brien leaves the car to the point that the defendant gets into the vehicle, as evidenced by the videotape, there was a cassette tape that was enhanced, and you can hear the defendant to say, "Call Bugsy." And that cassette tape, let's just play it one more time here. You'll get an opportunity to play this again while you're deliberating, should you choose to. But let me play it one more time here for you. I know that when the dog is barking, it's a little difficult to hear. Okay, call Bugsy. Now, Officer Lepson testified that Bugsy is Efren Barajas, a 16-year-old jump-in for Whittier Barrio Loco, self-admitted gang member, admitted to Detective Lepson that he is a gang member. And also that Bugsy, there's only one Bugsy in Whittier Barrio Loco. He's it. And also that Bugsy on May 1st, now this incident happened on May 16th. On May 1st, had been stopped in the field and had Little Man written on his hand and a phone number. And Bugsy admitted to Detective Levson that that was Little Man, this defendant that's in court today. Bugsy also lives right across the street, as you'll recall, from the location of where this occurred. But the cassette tape pretty much says it all. And then you've got 120, number 2, Don Page, Mark Hill, count 1. This will be your 120, number 2 lit for 5 minutes, you all. The defendant, Dawn Page, appeals from her conviction on 10 counts of delivery of a controlled substance. One of the issues in this case is whether the trial court erred when it refused to instruct the jury on entrapment. The case against Dawn Page arose out of an undercover operation. A man named Mark Hill was the agent in this affair. After he met Dawn Page at a music shop where she worked, he took part in several drug transactions with her until the police arrested her 1 year later. To establish the defense of entrapment, the defendant has the burden to prove that the agent persuaded her to commit a felony, and she must prove it by the greater weight of the evidence. If she meets her burden of proof, the state then has the burden to prove that she was predisposed to commit the crime, and it must do so beyond a reasonable doubt. This defense allows a person who would otherwise be guilty to go free. The fact that an agent furnishes the accused with a chance to commit an offense does not by itself show entrapment. The law says that an agent may engage in some act of persuasion in order to detect a crime. This defense exists only if the agent has used too much persuasion and only if the accused was not already disposed to commit the crime. If the evidence shows that all the agent did was offer to buy drugs, the trial court may decline to give instructions on the grounds that the evidence does not require it. The defendant argues that in a case involving more than one count, it is appropriate for the court to view each count as part of a continuing course of conduct rather than as 10 separate transactions. If this were a continuing course of conduct, Don Page would only have to meet the burden of proof once, rather than for each transaction, even though each one is a separate crime. We reject this approach since it expands the concept of entrapment. Don Page also says that because she was addicted to cocaine and because she needed money to support her habit, she was powerless to resist the offers that the agent made. She alleges that the agent preyed upon her need for drugs. She suggests the trial court should have considered these factors when it looked at the issue of entrapment. We reject this suggestion as unsound. Addicts are the ones who are most likely to sell drugs in order to raise money for their own habit. Don Page's suggestion would change the entrapment rule and would allow those who are most unlikely to commit this crime to escape conviction. Such a charge in the law would have a bad effect on the public welfare. We note that other states have also refused to make an allowance for drug addiction when the defendant claims entrapment in a drug case. With respect to count 1 in the criminal complaint, the record reveals that on one occasion, the agent came to the defendant's house. She was happy to see him because she had some cocaine in her possession that she could not afford, and because she had ingested some of it. The agent barely entered the residence when she pleaded with him to take the cocaine off her hands. She informed him that she did not even have enough money to pay for the cocaine she had ingested. The agent offered her $300. She then gave him the cocaine in her purse. With respect to, and so that concludes your lits, you all. They're very fair, so hopefully you can type one up and get one, okay? Have a great day, you all.